السلام عليكم. أرحب فيكم في معهد دبي القضائي في هذه الورشة بالتعاون مع نقابة المحامين الأمريكان بعنوان إدارة مكاتب المحاماة. طبعا هذه يمكن أول جلسة نعقدها للزملاء المحامين، وهي طبعا نتاج اللجنة المشتركة اللي شكلها معهد دبي القضائي بالتعاون مع بعض المحامين، وهذه طبعا يمكن بداية الغيث إن شاء الله. و يمكن حسب ما اتفقنا في الجلسة السابقة راح تكون برامج يعني راح ينفذها المعهد لمصلحة السادة المحامين، باعتبارهم يعني مثل ما يعني وضحنا في السابق ونأكد عليها في اليوم وغدا إن شاء الله، أنهم أحد أضلاع مربع العدالة اللي يشكلها القضاء والنيابة العامة والشرطة والمحامين. أتمنى لكم التوفيق، وإن شاء الله يعني أتمنى أن الورشة هذه رايح تلبي طموحاتكم، ومما تعكس يعني أيضا فوائدها عليكم وعلى أعمال ومهنة المحاماة. والسلام عليكم ورحمة الله وبركاته.
Good morning. First, let me thank Dr. Jamal al-Sumadi for inviting us here today for this presentation. This is a wonderful facility, so we're very glad to be here. My name is Paul Simonet, and I'm a program director for the American Bar Association's Rule of Law Initiative. I want to tell you a little bit about why the ABA is in Dubai. Why is the American Bar Association in Dubai? Some of you may know a little bit about the American Bar Association, but for those who don't, the American Bar Association is the voluntary national bar association of the United States. Perhaps you know that within the U.S., each individual state regulates the practice of law within its own state. But at the national level, we're the national bar, but it is a voluntary bar. We have almost 400,000 members worldwide. And our bar includes lawyers and judges and other legal professionals, and also includes members from other countries as well. The objective of our bar association includes the following. First, we serve our members. We provide benefits, programs, and services to promote our members' professionalism. That's what we do in the U.S. We also have a goal of improving the legal profession. And we do that by providing promoting high quality legal education, promoting ethical conduct and professionalism within the legal profession, and promoting public service by the legal profession. Another goal of the American Bar Association is to eliminate bias and enhance diversity within the legal profession. And finally, the fourth goal of the American Bar Association is to advance the rule of law. And we do this in a number of ways. We try to increase the public understanding of the value of the rule of law and respect for the rule of law. We attempt to hold governments accountable under the law. We work for just laws, including human rights and a fair legal process. We strive to ensure meaningful access for justice for all people. And we very much advocate the independence and professionalism of the legal profession and the judiciary. And it's this fourth goal of the ABA, the American Bar Association, promoting the rule of law, which brings us here. The ABA has a program called the Rule of Law Initiative, or ROLI as we call it, and that's who I'm with. I'm actually based in Bahrain. And this is a public service program of the American Bar Association to assist in promoting the rule of law around the world. We have programs now in over 40 countries. And we've been in the Middle East, North Africa region for several years. We have offices in, as I said, I'm in Bahrain, Qatar, Lebanon, Jordan, Egypt, Algeria, Tunisia, Morocco, and Istanbul. So in this region, we have representatives such as me. We have offices in all of those countries. And our reason for being there is to provide technical assistance and international best standards information to the legal profession. We've done activities with your Institute of Training and Judicial Studies, Dr. Kamali's, the National Institute for the UAE. We've cooperated with your Ministry of Justice in providing seminars. This is our first event in cooperation with Dubai Judicial Institute, and we certainly hope it's not the last. So the approach we take is not promoting an American approach to everything. We provide information and training on international best standards. And you're here today for one of those sessions. The law practice management. We certainly consider this issue and this area to be an extremely important area to assist in the advancement of the legal profession. The legal profession in your country is fairly young, relatively speaking, and we are certainly aware that of some of the challenges that you have. Our expert here, whom I will introduce more fully in a moment, Professor Bullock, certainly does not claim to be an expert on how to practice law in the United Arab Emirates, but she is very versed in some very good best practices on the management of law, and that's what we're going to share with you today. I've practiced law for many years, and I often wish that the only thing I would have to do is know the law and go into court. But as a lawyer, as we all know, you also have to manage your business. It's a business. You have to manage your cases, of course. You have to manage your money. You have to manage any people you hire. And that's not an easy thing to do. And oftentimes we lawyers are not very good at that. So the purpose of the workshop today is to share with you some information that we hope you will find helpful on some best practices on managing your law practice. Now, we've given this workshop elsewhere. And some of the material you may think, well, we don't do it this way here, so it's not relevant. And we understand that. But as your legal profession progresses, as you as lawyers decide for yourselves whether you want to practice in a solo practice or whether you want to come together as a law firm, this information will become important to you, and we are certainly aware that most of the law practice here, from what we understand and have been told, is solo practice. So you may think that some of what's going to be shared with you today just won't apply, but as you look towards the survival of the legal profession and you consider in the United Arab Emirates and Dubai forming or expanding into law firms, this will be of value. There's also much value here, certainly, for your solo practice of law as well. I'm not discounting that, but I wanted to make sure you understood. The second purpose of us being here and sharing this with you is we are very interested in getting to know from you what is most important to you as far as your law practice, as far as, future training purposes. We are very interested, and we plan to in the future continue to tailor the training that we will help with more specifically towards your goals, and towards specifically what you want to know. So we'll be asking you as we go through this material, maybe, is this relevant to you now, or do you think it will be in the future? And if not, what is most on your minds about your challenges for practicing law? Okay, so that's part of this as well, because we're going to take that information and go back with that and continue to develop our training. So with that introduction, let me introduce our expert. Dr. Joan Bullock is graciously traveled here just the day before yesterday from Florida in the United States to present this workshop. Professor Joan Bullock is a professor at the Florida A&M University College of Law, where she teaches law office management, contracts, commercial transactions, business organization, federal income tax, professional responsibility, and accounting for lawyers. Prior to coming to A&M, she was a tenured professor at the University of Toledo College of Law and has also taught at Georgia State University College of Law. In addition to her teaching career, she has practiced before the United States Tax Court and has assisted in many startup enterprises, including law firms, providing legal, accounting, tax, and general business services and advice. Prior to teaching, Professor Bullock worked as a certified public accountant for the Detroit office of Coopers & Lybrand. There she practiced in the areas of corporate tax, mergers and acquisitions, and valuation. A member of the Michigan Bar, she served as a council member of the Law Practice Management section of the State Bar of Michigan. She is also an active member of the American Bar Association, serving as vice chair of the American Bar Association Law Practice Management section. She has developed an expertise in law firm management and has extensive experience coaching and consulting with solo and small professional practice firms. So again, welcome, and without further delay, I will turn the floor over to you, Professor.
Good morning, everyone. I am happy to be here to share some of the law practice management best practices from the states. As was mentioned, I am a professor of law, and I've been teaching for almost 30 years in the law school. And as a teacher, I believe that learning is a two-way street, that learning is best when there is an interaction between the teacher and the student. And with that, I welcome your comments and your questions as I give my presentation, because as I am conveying information to you, I am very interested in learning about how you practice law. And there is a wealth of information in this room, because I understand that you all have been practicing for some years. And as we develop our materials for the future to provide in this region, it would be nice to provide or have some of your input to make what we provide more relevant to you. I would like to start this presentation with a discussion of managing your staff. And as an owner of your firm, it is a business. And even though as lawyers we think about the practice of law as a noble profession, and it is our calling to ensure that there is justice and that everyone has access to the legal system, it is very important, too, that we consider the business side of the practice. it is very important that we look out for ourselves and making sure that we can give our best to people in society who need assistance. And we give our best by making sure that our practice is able to support us in all that we want to do. So it starts with managing your staff and making sure that the people and the resources that you have available to you are able to benefit you and be most productive. In the States, when many people start as solos, they are truly one person. There is no secretary, no legal assistant. They start out by themselves. It isn't long before they realize that they need to have someone to answer the phones, to handle the office when they are in court. And I'm sure that many of you, if not all of you, can identify with that, with needing to expand your office and include support people. When you are looking at adding people, it is important to consider not so much the who you want to have in that position, but first look at the what. What position do you want to add to your firm? In the States, many times what the lawyer needs is someone to answer the phones. So you need someone who has a rudimentary understanding of running the office, but it's not important to know the law. It's not important to know procedures in managing clients, but it's basic office management. Having said that, many of these same lawyers realize that they need someone who is more diverse in their experience and being able to handle the office. Because office management is more than just answering the phone. It's more than unlocking the building in the morning and closing up at night. There is so much more support that is needed. So in expanding the staff or in adding people to the staff, it is important to look ahead and to think about how you would like to utilize that person beyond just answering the phones. Is it necessary that you have someone who can assist you in the legal preparation of a case, in handling, in not only typing documents, but maybe being able to pull various provisions from forms and having an understanding of what form or what provision or paragraph to include in a particular form. When someone is needed with that level of judgment, then it is important that you have a position that includes more than just a secretary. You would want someone who's a legal assistant. So what I am saying is that first consider the position you want filled. What do you want that person to do? Not only for the short term, but looking ahead in the future. Oftentimes, in terms of budgeting for the firm, it is not, the person is not able to hire 2 or 3 persons. So it is important for the lawyer to hire that one person who can cover many different areas within the firm. So determine the criteria for the position. If the person needs to be able to type, have familiarity with computer software, have an appreciation of the legal forms in the court system, have knowledge of the other attorneys in the region, if those things are important for that person to have, then make sure that the position includes all of that. Once you set out the criteria for the position, it becomes easier to look for the person to fit that position. In the past, when I've talked to various solos in setting up the office, they do it reverse. They hire the person first and then see how that person can help out in the office. Oftentimes it's family members or a friend of a friend that they would bring in. And it isn't long before they find out that that person does not work. And the reason why is because they focus on the who, just by bringing a person in and then trying to have that person fit in the office. But the focus should be to look at your office, find out what it is you want, and then find a person to fit in your office. This is important because the cost of turnover is high. As a business owner, it is a cost to fire or release an employee and then hire someone else. There is downtime when you are without someone to support you. That is a cost to you. It is a financial cost and a mental cost. There is also the cost of retraining. There is further the cost of employee morale. If you are the only other person in the office, you feel it. It's an emotional cost. But if there is another employee or other employees, that the employees can suffer from a lack of morale when someone leaves, especially if they leave in a bad situation. So consider the cost of turnover when you are hiring someone. The other thing in looking at adding staff and managing your staff is to consider your expectations for the position. What is your goal? Is it merely to delegate routine tasks? Is it to have someone add more judgment to those tasks in terms of completing forms, talking to your clients, asking questions, assisting you with the preparation of the case? How much supervision is required for that individual? And are you able to provide that supervision? The goal in adding anyone to your staff should be to delegate some of your responsibilities to allow you to be the most productive with your time. In the States, I tell my students and other legal professionals that delegation does not mean abdication. It is important that we not only hand over some responsibility to the individuals that we hire, but that we appropriately supervise them and realize that as owners of the practice, that whatever deficiencies that person may have, it falls on us, that we bear the risk of that because it is our law firm and it is our reputation at stake. It is our reputation at stake. As lawyers, all we have is our reputation. And once we lose that, the public has no confidence in us. And society as a whole has lost something when we have no credibility. So it is very important that we guard our reputation, and our staff oftentimes is the face that people see for our firm. In managing the law office, it's important that we see the business of the practice as a system. In any business, the business can only be run if it has some self-sufficiency. When the business is dependent on the owner, the business will fail. Because when the owner removes himself or herself from the business cannot continue. Especially as solos, it's important that there is that we consider what happens when we take vacations. What happens when we have emergencies that we have to handle? What happens when we want to retire? What happens when we are incapacitated in some way, have some debilitating illness, or if we die? What happens to that practice? We don't wait until that eventuality occurs. We have to start thinking about it now. And the best time to think about it is at the start of the practice. How will that practice continue if you are not there? And how will that practice continue even when you are in court? What is going on in your office when you are in court? Who's running the practice? Who's answering the phone? Who is talking to other clients who walk into your office? Do you have something set up? A system needs to be developed so that no matter where you are, whatever you are doing, your business is continuing to work for you. We see the McDonald's. I see some of the McDonald's in the area. And that is a franchise, but it is a system. And I can go anywhere in the world, and those French fries will taste the same. Why is that? It comes frozen. However, do I get it as a consumer frozen? No, I don't. It's not. So it may come packaged, and that's uniform, but the taste of it is the same. I can close my eyes and I wouldn't know where I am in the world. I might feel that I'm in Florida because that French fry tastes the same here as it does in Florida. How does that happen?
Because when they give them, I think when they give the companies, the other companies, to offer their product, I think there are some terms. They should stick to that one. That's why when you go everywhere, they are the same thing.
Mm-hmm, mm-hmm. Okay. And so, as you say, there is a license. However, with the system, there's a system in place that that for anyone to get a license, they have to follow that system. There are rules that are in place. And all the successful businesses, whether it is a franchise or otherwise organized, there is the thought about having a system, because you as managers and owners of your own business, you have to yourself develop a system. Ray Kroc formed McDonald's, and he purchased the hamburger recipe from this family and it wasn't because they had the best hamburger, but he saw that every time they cooked the hamburger, it came out the same way. And he was fascinated with that. And he took what they did and rolled it out nationally. And that was a system. It wasn't the hamburger that he bought the system. And that has made him very successful. And as we know, he's gone, he's passed on now, but he at the time was not making the hamburgers and making the fries. He hired someone else to do that. and he had the system in place to make sure that they did the fries a certain way, the hamburger a certain way. And every successful business, whether it's Ford, whether it's Toyota, or even for your law firm, it's the same concept, developing that system so that there is uniformity. And that way you can go to court, you can take a vacation, and feel comfortable and confident that your practice is being run the way you want. And that is, in the end, in talking to the lawyers in the states, when I ask them why they're interested in the practice of law, part of it has to do with being able to work on their own and more the noble sense of providing justice and representing people. But how do you work on your own? Do you want to create a job where you're chained to your desk every day, chained to your clients and running from one thing to the next? No, that's not what you want. You would want to have a system in place that would free you up to be the most productive with your time. So in light of that, what we have in the states, we have an employee manual and a policy and procedures manual. And we would provide that manual to the staff. And it would include our procedures, the forms that we would use in the practice, our expectations of how the firm is run, so that even if we're not there, the person can read it and understand exactly how we run our practice. As lawyers, it is important that we communicate well, that people understand what it is we want to accomplish. That is in the court system as well as in the office. So in the office, having a written manual in place where we clearly communicate our expectations to our employees is beneficial. In the first handout, if you would turn to that in your information, it's the first handout that's, I believe, labeled Policy and Procedures Self-Audit. Provide some of the questions that you can ask to make sure that you have, in developing a system for your practice, that you have some procedures in place. Surely not all of these will be applicable to your practice, but these are things that you can consider and modify as best suit you. As mentioned, it's best again to have the manual for the employees that would cover information. For example, what time does your office open? What time does it close? How early do you expect your employees to arrive prior to opening? If the phone needs to be answered, who is to answer the phone? And if that person is not available, who else should be answering the phone? When the phone is answered, what is the standard greeting? If you look in many businesses that are service-oriented, there is some discussion with the employees as to having a standard greeting, because that is part of the culture of your firm. In the States, we talk about having a brand recognition or having some sense of making ourselves unique, even as lawyers when we compete with each other. Why would a client come to my firm rather than Mr. Simonette's firm? And sometimes it's as simple as how someone greets the prospective client over the phone. How is that person received? So having that in the manual, where this is the how one should respond on the phone, how one should handle prospective clients, the questions that one should answer, and the overall receptivity of the office should be included in the manual. The dress of the employees. What is the dress code? How formal does your firm want to appear? What are the benefits for the employees? Holiday time. In the States, we have flex time for people who want to work part-time or come in at different hours because they have maybe family issues, taking care of children, taking care of elderly parents. And so we would allow flex time. What is your position of having someone work from their home? With technology being used more in the practice, would you allow a legal assistant to work from home? Would you allow a legal assistant to take client files home? And if so, what would be the procedure for checking that information out and taking that information home? All that would be in the manual. In the manual would also include information about employee performance. How are you going to evaluate that employee? What are your expectations about what that person is to do and how well that person should do it? Do they understand your expectations? It is very difficult to evaluate someone when you sit them down and you start discussing some of the possible deficiencies they may have, and they respond that they didn't know they were supposed to do that particular thing, that they did not know that was part of their job responsibility. So having in the manual the information, a description of their job, your expectations, and then having an evaluation sheet where you would be explaining to them that this is the criteria by which they will be judged. So when you sit them down and talk to them, they have an understanding of how they're going to be evaluated. The Policy and Procedures Manual also includes not only information about the employees and their workday, their dress code, the benefits that you will provide them, whether they are going to be promoted and what's the criteria for promotion and things like that. But it would also include information about the legal preparation or the preparation of case management will be included. This particular can review, for example, in interviewing a client. That way, if you're in court and you have a legal assistant in your office and a prospective client comes in, that legal assistant would have a list of questions they would be able to ask the same way you would have asked questions. That way, the quality that you want for your firm in terms of what the prospective client is able to see, how they perceive your firm, is going to be uniform. Going back to my McDonald's example, when someone is interested in purchasing a franchise from McDonald's, they have to go through McDonald University. And part of the learning of McDonald University is appreciating all the forms, all the procedures that have to be in place so that when you or I go to McDonald's and get a hamburger or French fries, that it would be the same no matter what. And that is because they understand the forms and the procedures and making sure that everything is uniform. So with the Policy and Procedures Manual, as you are practicing, as you say, this is a good way in this particular matter, this worked or this did not work, or I think this question is relevant, start writing those things down, developing your list of what works, what doesn't work. Enlist also the employees that you have, because they also many times are able to interact with clients at times not able to. And they will to provide information or input on this manual of what works. They can say, for example, with this, when I ask this question, no one knows what I want. But if I ask it a certain way, the clients are more forthcoming. Add that to our manual. So it is good to ask for the input of our employees to see what works, what does not work, what offends prospective clients or clients. And by doing that, we make our firm and we begin to have more uniform approach to things. For me, as I get older, I forget things. I remember it today and I say, oh, that's good. I got to remember that. And then I forget. And later on, when I'm with a client, and in the back of my mind, I said, there was something I was supposed to do. There was a different way of approaching that, and I can't remember. But to the extent that we write these things down, that we start developing a checklist of what we need to have in a particular situation, what questions we should ask based upon the legal issue that a client has. It not only informs us as lawyers to make sure that we come across as much more prepared and competent, but it also allows us to take a vacation day, to maybe travel around the world or whatever we want to, or spend a day at home and allow the firm to be run the way we expect. Does anyone have any questions so far? I won't spend much time going over this policy and procedure of audit, but I think it is a very good thing to have for you to look to for the questions and to see if some of these, in terms of the audit inquiry, if some of these things can be implemented in your particular practice. But it is quite extensive, and the policy and procedures manual would include every aspect of your firm. It not only applies to employees, it not only applies to how you would set up a case and questions and forms and having that bank or database of information, but it includes even your equipment, how you operate the equipment. In the States, all lawyers are subject to ethical rules, or as we call them, rules of professional conduct. And some of those rules deal with confidentiality of client information. It's very important that we maintain the confidence of clients. So, for example, if we receive X, that fax transmission can have confidential information of the client in it. So even as to where we put the fax machine, is it out in the open in a reception area where other clients will be sitting? Would their eyes be able to see what comes across? So in the manual, we would have something about the fax machine, where it's located, and also who should get the fax. If the information is very confidential, and we never know what might be coming off of that fax machine, we need to have in a policy and procedures manual who is to retrieve the fax. And then what will they do with the fax once they retrieve it? Can they go on their lunch break and just leave it on their desk if it's a receptionist so anyone who comes into the office can see it? What is the procedure? What is the protocol? Same way with mail, who receives it, who opens it, what do they do with it? If it's urgent matter, do they know to give it to you? Do they know to alert you so that you can comply with all the relevant deadlines? So this manual can be very detailed. And as you are practicing law and as you are seeing that things you want to make sure are taken care of on a detailed level, start writing things down. This manual need not be very formal. It can be points that you can say mail retrieval, and you can just have little points as to what the person should be focused on in terms of how quickly they should provide you with that information. When do you want your mail? When do you want to be disturbed? All those different things, and write it down and include it in the manual. So it's not important that it be a very formal document, because this is internal. It is for you. But it is important that it have some detail so that you can start freeing yourself up from the office, and you can focus more on the practice of law, and you can focus also on being the most productive with your time. There is also the legal matter checklist. In the states for practice areas, we have, for example, bankruptcy, real estate, business litigation. So when a prospective client comes into our office, we need to be able to ask questions that are pertinent to their matter. The clients do not come to us with the legal issues all formulated in their heads. They come to us very emotional. Someone has hurt them, and they want justice. And sometimes they bring in a lot of information, some things relevant, but many things not relevant. And we have to get them to focus and sort things out as to what's relevant and what's not relevant, in making sure that we can represent them. Are they giving us a legal issue that we can handle? Is this something that we can represent them on? In order to answer that question, we must be able to get them to focus by asking them the right question. What are those right questions? Now that you've been practicing, you have a sense of what questions you should be asking under certain circumstances. And the more experienced we all become, the more adept we are at asking the right question and getting our prospective client to focus. Having a checklist of the questions we should ask in a particular practice area helps us to make sure that we ask all those questions, so that there are no omissions when it comes to the legal representation, that our clients, who sometimes are not so forthcoming, that we make sure we get that information. Sometimes clients don't give us all the information that we need to represent them because they are afraid that we may choose not to represent them if we knew the truth. Or sometimes they do not tell us things because they don't think it's relevant. But it's up to us to determine what is relevant in building the case, because we are the lawyers and we are the experts, and they are relying on us to know what is relevant to present to a court. So it is important to have those questions, the appropriate questions that we may ask the client to get that information. Having a checklist of these questions for each practice area and for each legal issue is helpful to include in this manual, so that even when we are not in the office, if we have a legal assistant or someone else to assist us, they can help out by asking some of these questions. And then later on, when we look at the answers, we can make the determination as to whether this person presents a legal matter that we can handle and whether we want to take the case. If there are any rules, ethical rules related to your jurisdiction, that should be included in the manual as well. As I mentioned before, it is very important that we have a good reputation in the community. And it doesn't take long for our staff and our support people to damage, unintentionally, our reputation if they don't know the rules. As owners of our business and of our firm, it is our responsibility to make sure that the people that we hire know the rules within that jurisdiction. We should have, in the States, what we would do is to have our staff go to seminars and workshops to become updated on the rules. We sometimes have lunches where we have staff lunches, maybe on a monthly basis, to discuss and have that interactive discussion regarding the rules and how they are applied and are implemented in our firm. And also, even for ourselves, it's important that we remain updated on the rules and how they apply to our firm. And we do that, as you are doing here, coming to courses and seminars, whether at an institute or at a local university, subscribing to legal newspapers, magazines, and journals. But bottom line, you want to have an office policy where training is not something that is haphazard, but something that the staff as well as you, that there is an expectation that you are continually learning. In the States, law changes. And it is important that we as lawyers keep up with the changes in the law. We are the controller, so to speak, within the legal profession. And in the States, there is no other office, there is no other profession that a person can go to if they have a problem in the legal system. Therefore, it is important that we remain updated. How much time do I have? Okay. The other thing in dealing with managing the law office deals with conducting meetings. And it seems simple enough to say, why do I need to learn about conducting a meeting? But time is valuable, the time of your staff and also your own time. And it is important, as I mentioned before, that your expectations are known and that you are able to convey your expectations in a clear way. As lawyers, it's very important that we communicate clearly. In doing so, whether we have meetings with our staff, other attorneys, our clients, we should have a written agenda prepared prior to the meeting so that everyone who attends knows the scope of the meeting, what we're going to cover, as well as for how long. Time, again, is valuable. It makes it easier for people to plan when they know it's going to be only an hour that they need to take. And then be mindful of that time and only have the meeting for an hour. Sometimes, however, we are not able to have meetings with an agenda. The urgency of the matter requires a meeting to be held quite quickly. In that event, when the meeting is held, there should be an announcement as to why everyone was called, what's going to be the scope of the meeting, and what is hoped to be accomplished. At the end of the meeting, it's important to have these, what we call action items, where we would say, this is what we discussed. And these are the things that we are going to have done now that when we leave the meeting. That this particular person, the legal assistant, is going to check on this particular file and get back with me by tomorrow. And I am going to call the opposing counsel to get certain information and give it to my legal assistant by tomorrow. So that way everyone knows that before we leave the meeting, what our relative responsibilities are and what is the timeline by which we are to carry out those responsibilities. During the meeting, it is good to have someone keep minutes. If you are conducting the meeting, it's sometimes difficult to conduct the meeting and do the minutes. So if you have someone else who can prepare those minutes, it would be better. And then have those minutes distributed to all relevant parties soon after the meeting so that everyone the information is still fresh, and also as to the action items and the timelines that people know what it is they're supposed to do. That way, when it comes to evaluation times, if we need to go over that in terms of how people are carrying out their responsibilities, what your expectations were, it's very clear because things are provided in writing. There is communication during the meeting saying, this is what I expect from you. This is what I need within a certain time frame. And that way, if there are any questions or concerns, it could be brought up during the meeting.
Question about the policies and procedure manual. It seems as your thought is a comprehensive document, should contain everything with regard to the management of the office internally. Actually, I need to know your thought. What about the general business principle and code of conduct, if it is any? It should be included in such documents, or it needs a separate document because it has a special nature?
The code of conduct, which is so important in the legal profession, should be in several places.
Okay.
It should be in the manual because that is a resource that the employees would be looking to for information as it relates to clients or other aspects of the office. And so the code of professional conduct relates to everything that a lawyer and the legal staff does. So that should be included in the manual. And it should also be included separately that they can make reference to. And further, it should be certain rules or certain important things of the ethics rules can be placed in different parts of the office that are away from client eyes, but need to be conveyed to the employees. For example, in the States, the rule regarding confidentiality of client information is very important. And in the implementation of that, it goes so far as to have the employees not talk about client matters in the hallways, at lunch, or in other common areas where the information can be heard by other clients or other people who do not need that information. In the States, we have the lawyers, we have paralegals, we have secretaries, we have couriers and runners, and it's not necessary that everyone in the office be privy to information of the client. And further, the lower down the employee is, the more likely we're going to have turnover. For example, we might have a very temporary employee who comes in and runs information from to our office to the courts. So that's a courier or runner. That's not their lifetime job. That's something they're doing just on the short term. It is not necessary that that person, in most instances, know what is going on in a client matter. And we have as our rule that we do not want to share that information with that person because they are here today and who knows what they'll be doing tomorrow. They could be working with a competing firm or doing other things, nor do they appreciate the gravity of complying with our rules of professional conduct. So having those rules not only in the manual, not only separate, but having them listed what the employees should not do and making sure that they follow maybe in the kitchenette area where they congregate to have lunch is important. We have had situations where secretaries, where they meet for lunch, maybe with another law firm and so forth, and they're just talking, and they would say, guess who came into our office today? Some celebrity client or someone, and they want to share the gossip and so forth. They can't do that. As much as they are bursting at the seams, wanting to tell who came in the office, so-and-so came in the office, can't share that. Because in the States, even as to coming to see a lawyer, it's done in confidence, especially when we're dealing with high-profile and celebrity individuals. So having our employees appreciate the need for our clients to have confidence is very important, because we can lose that client because it was found out that they were seeing us. If I'm a divorce attorney and there is, it doesn't necessarily have to be a high-profile client, but it could be someone of some means who's coming to see me. The mere fact that they are coming to see me, a divorce attorney, is telling. Why else would they be seeing a divorce attorney? I'm sure not just to have lunch with me. So so if the newspapers find out about it, and so they usually come in the back door with shades on and so forth, or I'm meeting them at their home, or it's much more clandestine for that reason. So my staff needs to appreciate the importance of confidentiality. So those particular rules, depending upon my client base, I would have prominently listed in several places that they could be continuously aware of it. I would have in my monthly meetings conversations about that. Many times, let's say with a high-profile client, before they don't just come in off the street usually. They would usually call and I would tell them, come in and see me on a particular day. I may have a staff meeting in preparation of that person coming or anticipation of that person coming to tell the staff that this high-profile person is coming in and this is how I want you to conduct yourself. Either I don't want you to be seen because it's important for this client not to be seen by my staff, and this is how I want handled. Because it is very important that that client feel comfortable that we will maintain that confidence. So when it comes to our ethical rules, what's important for your firm? You want to pull those rules out and post somewhere and make sure that your employees have that information conveyed properly. And I remember, as an aside, I'm also a CPA, or a certified public accountant, and even though the ethical rules of accountants are not as stringent as the legal, we still have to maintain confidence. And some of the high-profile clients there, it was important to them that not anyone worked on their client matter. They only wanted the partners to work on it, or certain people. They did not want their file spread out to everyone. Because even if we as a firm, we had rules as to what we could convey outside of the firm, that client did not feel comfortable with too many people being privy to their personal information. So having a sense, and we'll talk a little bit more about that when we go into client relationships, but having a sense of who your client is and what it is they want is going to be very important, and making sure that we are in compliance with our ethical rules, that's going to be very important. Are there any other questions before I continue? I want to continue on the discussion of managing the law office and focus on timekeeping. In our country, in the United States, it's I think, a bit different in that we keep track of our time often on an hourly basis or a quarter time. And the reason why is because we bill frequently on an hourly basis. We are moving away from it a bit, but still the majority of attorneys bill for their time on an hourly basis. And so that is why the primary reason why we keep track of time. Outside of keeping track of time for billing purposes, it's good to keep track of your time, and as well as the time of all of your support staff people who are working on client matters, for you as the owner to gauge the financial performance of your firm. In the States, there's always the discussion of whether the practice of law is a business or whether it is a profession. And I always say that it is both. The practice of law, that's the profession, but the business of the practice, that's a business. And we have to be cognizant of that fact, that it is a business. And looking at that business component, it is important that we as owners of that business understand the financial performance of the firm, to know whether we are doing well financially or not doing well financially. So keeping track of time helps us to gauge the financial performance of our firm. There is a saying that time is money. And in law, our time is what we give to our clients. And to the extent that we make good use of our time and productive use of our time, we're able to handle more clients. So it would seem that the more time we have, the more money we can make, and the more financially viable our firm will be. However, time is limited. We all have only 24 hours in a day. We can't get more time, at least not on the individual basis. We can leverage our time by hiring other people, which is what I had been talking about earlier. The reason why you would hire people is to leverage your time, where you can start focusing on more higher level thinking in terms of the management of your firm. Where do you see it going in the next year, 5 years, 10 years down the road? Looking at succession planning, considering the practice areas that you have right now versus in the future, how complex the cases you want, focusing on the clients that you want, start weeding out the non-productive or the problem clients and focusing on the higher quality clients for your firm. That is what you as an owner would be thinking about. Leaving for other people the opportunity to work on particular client matters. So you can increase your time by expanding your staff. But nonetheless, time is limited. We each only have 24 hours in the day, and so to the extent that we cannot add more time, more minutes to our day, then it is important that we learn to keep track of it so that we can be most productive of it. As the owner of your business, keeping track of that time, seeing how your people are utilizing the time given to them on client matters and being most productive is going to be helpful. In recording time, the key is being diligent in that recording as well as consistent. Whether you have a legal assistant that you need to have the time recorded, or as a lawyer having that time recorded, all the services that are provided to that client should be tracked and recorded. So whether it is a phone call, I record the time. If it is correspondence, drafting a letter, I record the time. Doing research on a client matter, I record the time. Having the client come to a meeting with me, I record the time. Going to court for that client, I record the time. Talking with opposing counsel, I record the time. Sometimes I have to enlist the assistance of other professionals, for example, accountants, actuaries, or the like, or other expert witnesses. I record that time. After I record all that time, and for the services, as well as keeping track of the services, if I have to make a long distance or an international call, what's the cost of that call? What's the cost of copying? I would get an amount that I am spending on that client. What is my cost of production? What does it cost to represent that client? And that would help to inform me in the future as to how much I should charge for handling a similar matter for a different client. At the end of the day, in order for your firm to be financially viable, you need to be able to keep track of the cost and making sure that your revenue is higher than your cost. Otherwise, you are giving to the client something that you're not, and not getting anything back for. And no business can last a long time by spending more than it makes. So keeping track of your time is just the beginning of developing your financials so that you can gauge your financial performance. I have included in the handout, and this is handout 2 on timekeeping, billing, and collections, self-audit. Again, this is something that we won't spend much time on here, but you can look at your leisure afterwards. But the first page focuses on the fact that it is important to be diligent in the recording of your time and for all the other legal assistants to record their time. And as a third point on that first page, as it asks, do you realize that failure to record time can result in huge financial losses for a firm? I want to speak to that just briefly. As I mentioned in the States, we, in general, record our time because we charge on an hourly basis. And as I'm sure many of you may feel here yourself, when you practice law, you're so busy practicing law, you don't have time to deal with the management or the administration of your office, including keeping track of your time. And in the States, we have people who are, they wait to the last minute to write down their time. They're so busy practicing, going to court, seeing clients, and that they don't have time to record their time contemporaneous to that activity. They might wait to the end of the week and then list all their time. What has been shown statistically is that when one waits to a later date to record the time, that people lose time they do not track all the hours, the minutes that they have put into a client matter. As a result of that, since we charge usually on an hourly basis, that is time that we're not able to bill for. The attorney has worked those hours, but cannot remember that they put in that many hours. They might have put in 30 hours on a client matter, but they only remember or can write down 20. So that's 10 hours of lost time. So as the owner of the practice, when they look at a person and say, they only put in 20 hours for this client matter, I can only bill out 20 hours. What is that employee doing the rest of the day? They've only put in 20 hours. Whereas in effect, that person has put in 30 hours in that client matter and maybe some additional hours for other administrative things. The problem there is that as the owner, when I see that someone has only put in 20 hours, well, gosh, they don't look too productive. I got to give them more work. And then when I give them more work, they get upset because actually they put in 30 hours. So keeping track of time is not only good for us in terms of hourly billing, but for you in managing your business when you have other employees working for you, when you appreciate the amount of time they're putting into a client matter. And you are the expert in your office, not only as the manager, but as the lawyer. You may know that it should take about 10 hours in this matter. If someone is putting in 20 hours, what's wrong? Why is this person putting in 20 hours for something that should only take a person with that level of education and skills? Why are they putting in 20 hours or 30 hours? As a manager, you need to find out what it is that you need to give that person to have them shorten their time. It could be something where you don't have the policy and procedures manual, where they didn't realize they have a form, and they reinvented the wheel, creating their own form. I remember when I was an intern working for a firm, and I didn't know anything, truly wet behind the ears, and I was their first intern. They didn't know what to do with me. They took me to court. They had me sit on meetings. They didn't know what to do with me. They had no manual or anything to give me and tell me to read up on. And one time they wanted me to draft a complaint for to submit to a court. And on the local level, and I'm sure it's similar here, that each court has its own set of rules as to how the paper, they want the size paper, the caption, and exactly how it should be put out in the pleadings. So I went to our general form books and I spent days, because I was new and I was still a law student, coming up with this wonderful complaint. And after I gave it to the attorney said, "Oh, the court has their own form. Here it is." And if I had known that, all I had to do was fill in the blank. But I spent days on that. And that's because I didn't know. And that's also because the attorney did not think to tell me, because it's something in the practice he knows, and it just didn't come to him. I was a new intern. They didn't know what to do with me. So part of that is the policy and procedures manual. But the other part of that is because I'm keeping track of my time, so that he, as the manager of me, can see how I'm being how productive I am or not, can say, "Well, Joan, that's not right. That's not right. You should not spend 2 days on this complaint where it's a one-page sheet." And not only that was a one-page sheet, but the court required that sheet. So even though I had done a beautiful job, the court would not accept it because it was not on the paper, it was not how they wanted it. So appreciating what it is that the person is doing, keeping track of their time, is important for you to have. So when people don't record their time, as I mentioned before, they lose track of the hours that they spend. And even if you do not need it for billing purposes, you need it for management purposes. How are your people utilizing their time? Are they utilizing it in the most effective and productive way? What is it that they need in order to be more productive? Is it developing a checklist? And going back to those checklists, and in preparing the policy and procedures manual, it is not necessary that you do all the work. As I mentioned to you before, your employees are a wealth of knowledge. And when that legal assistant is that this is what I did, and let's suppose they did a very good job on it for this particular matter, ask them to write down the steps that they took to carry that out. So that way it's memorialized not only for themselves, but for anyone else who comes into their position. Ask your support staff to memorialize how they carry out their day, so that if that person chooses not to come in because they are sick, then someone else who has to step in, even temporarily, would have the list of how that person carried out that day. The other reason why we ask employees to do that rather than having you is because the employee is the one closest to it. And they know all the nuances that you aren't necessarily privy to. You are not necessarily exposed to it. So getting their input is helpful. Are there any questions so far on this? Or any comments that anyone would like to make? If I may ask a question of the group, in terms of the procedures of the office and managing the office, are you mainly solos, working by yourselves, or are you working with several employees? If someone would be willing to respond.
I believe most of the lawyers here in the UAE, for sure they have some employees in their offices. And this is a must, I believe, in all of the offices, definitely. Beginning of a secretary and maybe legal consultants, few of them. But I believe this is in all of the law firms here.
Okay. And I would think in terms of secretary time, at least in the States, we don't really track their time too much because they are answering the phones and handling matters as they come up. Whereas legal assistants, and what we have are paralegals, who many of them, they go to school to learn how to support the lawyers. And oftentimes, they know more than us when it comes to the routine, repetitive tasks, the forms that need to be filled out, because that is not something that we do. So they know more oftentimes about how to fill out those forms and what's needed for the court in that regard. So that we need to keep track of their time. But secretary is not so much so, unless your secretary is someone who is also assisting on the other legal matters beyond just office administration. If there are no other comments about timekeeping and recording the time, just briefly to talk about computer software. There's a lot of software out there that you can look on the web, and if you Google for law practice or case management, timekeeping, and the like, you'll be able to get a lot of information on it. I don't know necessarily how well the software would be able to be utilized here, but we do have some. And what I tell the students in the States, when they're considering software, consider what they want to use it for. Of course, Many of them want to use it for keeping time, because with the keeping track of charging on an hourly basis, usually we want to make sure we keep track of time. As solos, we don't want to spend too much time with the administration of the office. So we want our software to not only keep track of time, but we will also like to be able to transfer the time that we have recorded and to be able to invoice the client. There's software out there that's strictly timekeeping, and it doesn't have an accounting component to transfer that information over for billing purposes, and therefore they'd have to get another software, which means that they're inputting twice, and that is not productive. So finding software that is integrated, where the time is recorded and it would immediately transfer over into the accounting, so that way they don't have to input. In the States, we have several, but primary ones are Abacus Law and PC Law. And with these, you're able to, for example, if a client calls on the phone, or if I want to call a client on the phone, when I get the client, I can, in my software, which I can see on the computer, push a button, and when I start talking to that client, the clock is going. But the clock is going as it relates to that client. It's already keeping track for that particular client. And then when I hang up the phone, I push the button and the clock stops. And so that time is now recorded for that particular client. And not only for that client, but I would have included in the software that is for this particular client and this particular legal issue. Because many times we have clients who come see us at different times on various legal issues. So I can have in the software that I'm talking to the client on this particular legal matter. It's keeping track of my time and automatically sending that over for accounting purposes. So that makes better use of my time. But as I'm sure you can see, that if I don't put anything in the software, and if I don't push the button when I am making that phone call, it's for naught. So it's not only must we have the software, but we must make sure that we utilize it, and more importantly for our staff, that our staff consistently use it as well. Because we, again, as managers of the business, we can take this data that is inputted in the software to see how productive our staff are. It could be as simple as looking at the phone calls. Why is the legal assistant talking that much to that particular client? Is it that they're not communicating effectively? Is it because we have a needy client? What is it? We may need, if the client is too needy, and looking at from a managing perspective, if that is a problem client, over time I might want to get rid of my overly needy clients. So again, keeping track of time, having that software track all that information is helpful to me as a manager. But along with software that keeps track of time and that can have that information flow into accounting and billing, there's also software that allows us to share information not only with people within our office, but also with other attorneys. You may be in a situation where you're collaborating with another firm, perhaps on a large matter, and you have a document or a couple documents that you will be utilizing. To be able to have several people working on that document at one time, or having that document available, would be helpful. Sending it by email is difficult at times, because if the document is very large, and as lawyers we sometimes use a lot of words and have lengthy documents, so it makes it difficult to transfer the document over email. Further, there's sometimes things are lost as to which version are you transferring over? Is it the right one? Did you save it and the like? But what we have now is SharePoint, Portal. Those are two software that's on the web, which would allow us to have a document, type it up, do what we want with it, and then we would upload it onto the web. So it's not only on our hard drive or servers in the office, but we have uploaded a copy on the web, or as we now call it, the cloud. And that way someone from another office, or for example, I could be in the States working on this document, I could put it in SharePoint, and then you would get on SharePoint and be able to pull that same document down, work on it, put it back up in the cloud, and then I can see what changes. So we're continually working on the changes. SharePoint would keep track of those changes, and I could see the changes that you made. You can see the modifications that I've made, and so it's going back and forth for a final product. And that way, too, if someone else would join, they can have access to that document. So it works well as we are working collaboratively, whether as different firms, or if it's a matter of even within the firm where you have a legal assistant working on it and you want to work on it as well. Similar to what we're doing here with the Rule of Law Initiative, as we develop modules and we enlist support of attorneys in the area to comment on things, we can upload course material and say, this is how we're drafting it. What do you think? You change things, say this is relevant, this is not relevant, add that, we make changes, and we have that dialogue. And it's much more efficient than using email. And if we need to bring a third person in, it's not a matter of trying to bring that person up to speed through email. They have access to it immediately. So we see a lot of attorneys, especially with litigation, utilizing this software on the web or in the cloud because of the volume of the litigation documents, and having the paralegals work on particular matters, or looking at what's for discovery and inputting all of that up on the cloud so everyone can see the documents and add to those documents is important. Besides accounting and timekeeping software and software that will allow you to put things up on the web, there are customized systems. And those customized systems are just that. They allow you to customize software that's most beneficial for you. Here, when you have the local laws and you have the federal laws, and depending upon which jurisdiction, there are different rules. You may want to have a software that can capture those local variations, and a package, a prepackaged software program, may not be able to allow you to have those local preferences in place. So a customized system would be helpful. For any system, there's certain information that needs to be recorded, and one is, of course, the client's name, because we need to begin to keep track of that client and to see how we are expending our time and other resources to benefit that client. If you're in a firm that's larger than yourself and there are other attorneys who are involved, then having the lawyer's name or initials included in that record is going to be helpful. The date in which that person has performed the work, a description of that work, as well as the time spent on the case during the day is important. It is my understanding in fees that the fees basically are lump sum fees that you charge, not hourly or other types, correct? The lump sum, charge one price. Not always? Could you?
Sorry.
Oh.
The client. Some of the client, let's say European or American client, they request that we will bill them on hourly rate. Some other will, for court cases we mean. Sometimes for court cases it will be a lump sum fee.
Sometimes retainerships.
And
Sometimes there is retainerships between us and the clients.
okay.
So it depends on annual contract, which is discussed with the annual fees. So it is difficult to count the fees by hours.
Okay.
This is difficult.
Okay. So there is some variation then in the fees. So timekeeping may be important, especially if it's hourly. But even if it is not hourly, if you have that flexibility in determining what fee you want, because as manager of your firm, looking at financial viability, you may realize that charging this lump sum price is not financially viable in the future, that depending upon the complexity of the matter and the stages of the presentation, it may make sense to go an hourly rate or some other variation of billing. So keeping track of your time is still helpful then, just to give you a better sense of in the future of how you might want to bill and what's most profitable for you. So yes.
I believe also keeping the time is important for the evaluation of the fees, because sometimes you have a dispute between the lawyer and the client, and the client is challenging how much is the fee that you are supposed to take. And then the file goes to court.
Yes.
And the judge, according to the UAE law, the judge, in order to look how to evaluate the fee of a lawyer, he wanted to say that to see the effort made.
Exactly.
He wanted to see, this is one of the elements, the effort and the interest that we bring to the client. And one of the effort is the time.
Yes, and I'm glad you mentioned that, because we have that in the States as well, that when a client is complaining about the fee, that it is excessive, or believing that the attorney has been neglectful in the case, the court want to see or the bar wants to see the records, the time records. And if the person has not been diligently keeping track of their time, again, this is when at the last minute they're feverishly going back through the file trying to write down all the things that they did. And if attorney has been dealing with the matter, let's say for 6 months, trying to go back 6 months and say, what did I do? How much time did I put on it? We know that we wrote this contract. We know we negotiated. But how long did it take to draft that contract? How long did it take to negotiate? And this is where we lose our hours. And then just the psychological, the emotional upheaval of having to prepare records for court because we are in a defensive posture is not helpful. On one hand, we want to put in enough hours to support our case, but we don't want to be viewed as excessive at that point. How do we justify those hours when we are, after 6 months, going back and trying to write it all down? So keeping track of our time, even if it's not for billing purposes and hourly basis, in the event a client is questioning our bill, we can at least, even if it doesn't go to court, we can justify it. So when we have that system in place by keeping track of the client's name, keeping track of the lawyers and other legal personnel who are working on a client matter, not only the amount of time put, but a description, a detailed description. Because for those of you who are working in firms where you have your support staff, it is not enough for them to just put down that they worked on client A's matter for 2 hours. Well, what did they do? How do you prepare a bill when all you know is that they put in 2 hours? Will your client rush to pay your bill when the only thing you have is that 2 hours were spent. The client would want to or be more apt to pay the bill if you give a detailed description of what it is that you did for that client. And that's why it is important that everyone who is keeping track of their time and their efforts, that they include not only how much time, but a detailed description so that when you draft the bill, you can include as much of that description as you see fit to communicate to the client. Whether electronic, there is electronic timekeeping, and even in the States, many of us are still using paper timekeeping. There's a time slips method or the time ledger sheet method. The time slips, and there is a software program that was called Time Slips that focuses on this concept, where there are little sheets or little slips that you would write the client's name and description and the amount of time, and that's a slip. So every time you work on a client matter or any client matter, you fill out this little slip. And so at the end of the day, you would have several slips, and they would have carbon copies so that you would hand off the original back then to the support staff to collect those slips and to record it in some fashion, and then you would have your hard copy that you would keep for your files. Those slips then are utilized to keep track of the client time, so we'll get all the slips for client A together, all the slips for client B together, and then from there we can invoice the client. The other way is the time ledger sheet, where we would have a ledger, and on this one sheet I would be keeping track of my time for that entire day. Client A matter, then client B matter, client C matter, all on this one ledger sheet. And I would get all that information from the ledger, and then say, okay, if at the end of the week I'll have to go through every day's ledger sheet to find client A and all my different ledger sheets for the week, and then accumulate those and transfer that information either over to the client's ledger sheet and then to invoicing, or just straight over to invoicing. So it's a little more involved in that, at least with the time slips, all client A's I have in a bundle, all client B's. So it's a little easier from that perspective, from the whoever's accumulating and trying to record it for each client. But the time ledger sheet sometimes is more efficient for the timekeeper himself or herself, because you only have one page for that day, and I could look for that day and I could see my entire day as to how I spent my time, rather than being broken up into slips. But it's a little more difficult for whomever is recording the time and separating from this ledger sheet client A versus client B versus client C. Yes.
So it may be difficult for the lawyer to keep a ledger sheet. It's easier to make the time sheet, because while he is working in the day, he works on a file, suddenly a telephone call, he has to stop to answer the phone, maybe somebody interrupting, he has to stop the work. So putting it on a ledger, it's difficult to manage it. Whereas putting on a slip, it's easier. He can start, he can make slip.
For each client.
Yeah.
And whether it's electronic or not, even on the electronic version, it follows the same logic. So as I tell my students, with computer software, all they need to do is input, and the computer does everything else. But I tell my students, don't be lazy. Understand the logic of what's going on, because every once in a while there are glitches or something doesn't track well, and you need to be able to find out where's the problem. Why is it that I know I put in 10 hours, but it's saying 100 hours? Is it because I included only an additional 0, or is it somehow doubling because of something that I did? having an appreciation of the logic of how the information that is recorded flows through the software. How, for example, in the integrated system, where it not only goes into timekeeping, but it flows over into billing, making sure it flows over properly is important. So understanding it even on the paper version or the logic is important. But whatever method works, consistency is extremely important. Okay, good. There is also, for different filing systems, along with just keeping track of time, we need to be able to keep track of the client file. Nothing is more embarrassing than the client calling and you need to say, hold on, let me get the file and looking to get some information out or to add something to it, and you can't find the file. That has happened when in the states where we have different employees who are working on the file. How do you know who has the file at that particular time? Is it the legal assistant? Is it another lawyer? Or maybe you've forgotten and it's you and you left it at home but you don't remember. So having some system in place as to where the file is going to be important. But even more important is knowing is being able to maintain the file. What much do you have in the file? Back to the policy and procedures manual. How do you open a file? How you close a file? Most likely, as you add people, you will have support staff to add to build your file. There should be a certain protocol, certain procedure for the file. I know with some attorneys, it's as simple as here's a folder. We want the 2-hole punch at the top, so that way there are no stray papers. As you can see how sometimes you carry a folder if it's not bound, papers fall out. And when you have a lot of people in the office and the file is being transferred from one desk to another, pieces of paper can fall out. What happens if something that was vital for the case was on a little itty-bitty Post-it note, little memo, and it drops out? It could be vital to your case, but it's lost. But if every piece of paper, whether it's a little Post-it note or something large, is in this binder with the 2-hole punch at the top, and some attorneys might have the 3-hole punch. They're very particular. But either way, it is attached. Every document is attached. Then part of the procedure is chronological, having it starting from the one at the bottom is the oldest document, and as we go and as we keep inputting, there is a content. So on the folder itself, we can see exactly what documents are there. This is helpful sometimes when a lawyer needs to make a copy of something, or support staff needs to make a copy of a document. Take some of the documents out so they can copy this one. What happens if they forget to put it in? Because as the gentleman mentioned here, there was a phone call. Had to take the phone call, dealt with that particular client matter for maybe 15, 20 minutes. And after the phone call, you write that down and you forget that you had taken this out of the file and it needs to go back in. So what would happen is if there at least is a contents page which would say that here are all the documents that are included in this file, so when someone else is going through the file and they can see if they needed to find it, and if they could not find it, they could see that it at some point was in the file, then we know to search for it. If we do not have a listing of everything in that folder, we don't know when we can't find it, if we ever had it. So little things like that in terms of opening a file and having it in place and having some procedure would be helpful in terms of the management of your firm. But we have paper files, of course, but oftentimes we have electronic files. And those electronic files usually would be the documents that you are creating, the forms, the contracts that you would create for a particular client. Of course, that electronic file is put into that client's paper file. You convert that to paper for that client file. But also, that contract you created, you want to have that as a template or as a form that you can use in the future for other clients. How do you retrieve that contract in the future? Oftentimes, we handle a particular matter, and it's not the next day that you'll get the same matter, that you can say, oh, I just had this contract yesterday, use that as your template. What happens if it was 5 years ago? Are you able to retrieve that form? What happens if you don't remember that you created that form? Or what happens if it was a legal assistant in your firm that created that form? You don't know the existence of the form. How do you know to retrieve something that you don't know exists? Very difficult. So one, having the system in place that whatever is created is being able to be stored, and if it is in electronic fashion, that the name of it is such that you are able to retrieve it. So thinking about that name is going to be important to be able to retrieve it 5 years from now, whether it's by you or by someone else. In setting up filing systems, most systems are set up to be very client-oriented, so we start out with the client's name. So that way you can retrieve information based upon a client's name. The subject, for many of you, you may have clients who are repeat clients. There are different issues, especially in business clients. They present different legal issues. So you would have the client name, but you would also have various issues or sub-accounts. It could be a tax issue, so you have a tax category. You can have litigation where certain aspects of the legal issues that you're litigating, you can have different categories for those as well, so that in the event you need to retrieve something for that client or for other matters, you can say go to client A's matter and in a tax category. Have a category set aside for fees. Have a category set aside for the responsible lawyer involved in that particular matter. You may ask, why is all this relevant just for retrieval? It's not only relevant for retrieval of the document, it's more relevant for you as manager. Again, looking at the financial performance of the firm. How do you know that a client is profitable? You may, in your mind, think that the client is profitable because they've been with you for 5 years and they generate business for you. But just because there is movement does not mean that one is going somewhere. I have this picture in my mind, in the gym where people exercise, where they get on those stationary bikes and they call it in the States spinning. And they just exercise in one place, and they're on a bike. They're not going anywhere, but they're moving. So a spinner is different from a cyclist who is out on the open road going somewhere. They're both doing the same movement, but one is going somewhere and one is not. So the mere fact that there is movement doesn't mean that one is going somewhere. So the same way in our practice, sometimes we might like a client, there is movement, there is activity, and we say that client has to be profitable because we get a lot of business from that client. But if we have in our filing system, in our electronic search, where we separate out the categories, here's the responsible lawyer for the client, here are the fees, here's the subject matter, we can be able to track and see, well, what are the annual fees for this particular client? From electronic, the beauty of having an electronic system, We can ask for all the fees. It would congregate all the fees for that client, and we'll see at the end of the year, this is how much we charge that client. We can also see how much that client paid. And we can say, wow, I thought we made more money with this client. Or even if we made money for the client, how much time was spent? Was it worthwhile? So in our electronic filing system, excuse me, the name that the categories that we set up is helpful to us as managers of the practice in getting that information and applying it for financial performance, as well as looking at and evaluating our staff as to how they're utilizing their time and their expertise on those matters. Even if we have electronic files, in the States, many law firms are moving to an electronic environment, and they call it the paperless office. No papers. Their file room, no papers. Every file is digitized and on some type of electronic medium. My advice, and even for those who are paperless, they still have paper somewhere, perhaps off-site. What happens if technology crashes? Do they have a backup? Also, even if they have a backup, what happens if the medium changes? You may recall the computer, the older computers with the 5 1/4 floppy disk, the floppy disk that was this big. If you have stored any information on those old floppy disks, how do you retrieve that information? And even now we have things are stored on CDs and DVDs. What happens 5-10 years from now when we're no longer using CDs and DVDs? Our computers, many times we're not using computers, we're using phones and other smart technology that's very small. They can't take a CD. So how do you store your information? Therefore, if you store it one way, you still want to have a paper version in the event that you aren't able to pull off that information based upon how it was previously stored. How am I doing? Okay. Yes.
How long you need information? How long you need to keep a file once the file is closed? We have a court case, okay? We keep it normally, I keep it in my office for 5 years. I scan it and then I destroy. Is it a normal practice?
Okay. In the states, we have every state is different as to its laws. So in the states, we would have to look to that jurisdiction to determine if under the ethical rules, what are the requirements for record retention once the file has been closed? And then what are the procedures by which one should close and retain the documents? So that's the first point, look into that jurisdiction. Then secondly, if the jurisdiction does not have say anything regarding it, usually most would keep it at least for the statute of limitations for suing the attorney. In terms of, let's say it's the minimum time, the statute of limitations for a particular legal matter and a client to sue the lawyer on it is 3 years. Then a minimum amount is 3 years, because that client may come back and sue us, whether it's the fee or something else. We need to have that file. Oftentimes it's 7 years that people would keep the file. I don't know where they get the 7 outside of jurisdiction, but a lot of them, they would just keep it for 7 years. Also in the policy and procedures manual, when you mentioned that you scan your file in and destroy the physical file. We see that happening in the States as well, because the paper version is just too cumbersome. As you start building your practice, you have reams and reams of paper, and what a lot of law firms were doing were taking those paper files that were closed and moving them off-site to keep them stored somewhere else. And that's a cost. So being able to scan them in and keep them in the office in a digital format is less expensive, and it's easier to access because they're right there. There should be some procedure in place as to what you should destroy. In the States, we have something where we have to call up the client and ask them if it's any original documents. We make sure all the original documents go back to the client. It could be a birth certificate, maybe some other important papers. We make sure that goes back to the client. We oftentimes will ask the client if there's certain other information that they might want, and then we give that to the client, and we inform the client that we are going to destroy, so that way they'll know. We keep a copy of it, as you do, for scanning purposes, but we explain to the client that otherwise we are destroying it. But it is important to keep that information in the procedures a file. I want to relate. Sure.